Good afternoon. Thank you for being here. My name is Micah Allred, and I am a managing online editor on the Notre Dame Law Review. Before we begin, I'd like to share a few notes about today's panel discussion. First, a recording is being made of today's discussion, and it will be available later online, so be on the lookout for that. Second, on your way out, please feel free to take a grab-and-go lunch, and make sure you eat those in the Commons or the South Reading Room. And then finally, on behalf of the Notre Dame Law Review, I would like to extend my gratitude to the 4 other law school programs co-sponsoring today's symposium. They are the Religious Liberty Initiative, the International and Graduate Programs Office, the London Law Program, and the Program on Church, State, and Society. We would like to especially thank the Religious Liberty Initiative staff for their assistance in organizing today's symposium. With that, I would like to now welcome the Editor-in-Chief of the Notre Dame Law Review, Aista Zalapuga.
Thank you, and welcome to today's symposium on global religious persecution. This symposium is one of 6 symposia hosted by the Notre Dame Law Review, including the Notre Dame Law Review Reflection, which is the Law Review's online platform. Later this spring, the Law Review Reflection will publish 6 articles written by the authors here today. I now have the honor of welcoming our moderator. Professor Diane Desierto is Professor of Law and LLM Faculty Director at Notre Dame Law School, with a joint appointment in the Keough School of Global Affairs. You can read her biography along with that of the other panelists in the handout you received on your way in. Please join me in welcoming Professor Desierto.
Good afternoon, and thank you to the Notre Dame Law Review and the programs of the law school, the 4 programs of the law school that have organized such an important topic in today's discussion. I'm very excited to be moderating today's panel discussion, and before we begin, let me briefly introduce our panelists. As I noted, you can find their full biographies on the handout you received when you entered. Jorge Barrera Rojas is assistant professor to my right, the rightmost, is assistant professor of law at the University of Chile and the University of San Sebastián. He's also the co-authoring with María Celis Brunet, who is professor in the Faculty of Law, director of the Canon Law Department, and director of the UC Center for Law and Religion at the Pontifical Catholic University in Chile. This spring semester, Professors Barrera and Professor Celis are co-teaching a course on the international religious liberty here at the law school. Following their presentation will be Mark Hill, QC, who practices at the bar in London, who is extremely well known for his work in ecclesiastical law and religious liberty, and who is a visiting professor and distinguished fellow at Notre Dame's London Law Program. To my left would be Professor Andrea Pin, who is Associate Professor of Comparative Public Law at the University of Padova Law School. To his left would be Professor Brett Scharffs, the Rex E. Lee Chair and Professor of Law at Brigham Young University's J. Reuben Clark Law School and Director of their Center, International Center for Law and Religious Studies. And to the leftmost part of the podium is Mr. Nury Turkel, who is the current Vice Chair of the U.S. Commission on International Religious Freedom and the recipient of our inaugural Notre Dame Prize for Religious Liberty. Unfortunately, one of our speakers, who is right here in the center, attending virtually, Professor James Sonne, who is Professor of Law at Stanford Law School and founding director of its Religious Liberty Clinic. Unfortunately, weather circumstances prevented him being present here today, but I'm glad that he is here virtually. Thank you all to our panelists for coming and for sharing your thoughts for today's discussion. Before we proceed, and part of what I am personally interested in this topic regarding the protection of religious minorities and why this particular symposium issue for the Notre Dame Law Review will be particularly impactful, is that it brings to the forefront something that we probably have not considered, especially in international human rights law. The Pew Research Center notes that as of 2021, over 90% of countries in the world either have circumstances involving harassment of religious minorities or outright infliction of civil and political rights violations against religious minorities. The extent to which this is widespread around the world makes us all and provokes us all to think what is indeed needed to ensure the protection of religious minorities today, when there is so much democratic backsliding and a proliferation of autocracies and authoritarianisms around the world. Is the law still sufficient? Is this just an institutional or enforcement matter? Is this a question of looking at international responses vis-a-vis regional responses or appealing to domestic decision makers? Or maybe is this a hearts and minds issue of winning over the local majorities within populations that somehow also contribute to the religious unfreedom that we've seen today? So to begin this discussion, may I invite Professors Barrera and Celis to discuss their presentation on Latin America.
Oh, thank you very much to Notre Dame Law Review and the University of Notre Dame for inviting us, and also the law professors and authorities who are attending this symposium today. Persecution of religion grounds has generally been linked to a situation of extreme violation of human rights. However, not every act or omission that infringes religious freedom is in itself capable of being considered persecution under international law standards. Although, as you may know, the term persecution is not legally defined, doctrine and case law has established that severe discrimination, the cumulative effect or combination with other adverse factors can lead to a well-founded fear of persecution as well. So, persecution may also be a result of an accumulation of various measures, even if the violation of human rights concerned are not systematic or persistent. Under this scenario, a first look at international criminal law standards could show that almost none of the violation of religious freedom in Latin America, as Professor Celis will explain in a couple of minutes, can be qualified as persecution. However, there are a few exceptions of regimes that severely restrict the authority and activities of the religious communities, such as the case of Mexico, whose laws contain strict control of the state over religion and its practice. Our article tries to explain how extreme secularism may create a path for future religious persecution. That is why we decided to highlight Mexican case. In this sense, Mexican law provides a few examples of cases that could potentially be considered persecution if other factors appear in the future. This has been faced due to the court's interpretation of the principle of church-state separation, including the provision under which religious ministers are barred from running for office since 1933. The judicial branch has also currently opened criminal proceedings against priests and bishops for speaking up on moral issues that relate to the electoral contest. One of them finished in an annulment of one election, another in a sanction ranging from a simple reprimand up to a fine equivalent to $100. However, if the conduct is repeated in the future, they even could be imprisoned. The main question is whether these cases of extreme secularism may constitute persecution based on religious grounds. In this sense, and acknowledging that the difference between human rights violation and criminal acts, the Special Rapporteur on Freedom of Religion or Belief has stated, "It is not advisable to criminalize non-violent acts performed in the context of manifestation of one religion, in particular the propagation of religion, including because that might criminalize acts that could, in another context, not raise a concern of criminal law and may pave the way to persecution of religious minorities." Although this report does not constitute a case law nor binding international law provision, the authoritative interpretation from the Special Rapporteur on Freedom of Religion and Belief is quite important, saying the cases aforementioned are actually a criminalization for non-violent acts performed in the context of manifestation of one religion, such as the Mexican priest behavior, that may pave the way for persecution based on religious grounds. I take the microphone to Professor Celis.
Thank you. Thank you to the Law Review and the Religious Liberty Initiative for this invitation, and I'm very happy to see some of our students and colleagues here to share these thoughts about religious persecution in Latin America. I have to start to say that it's almost embarrassing always to talk about persecution in Latin America, because it's well known as a country where homogeneous religious trend in Christian religious. It's not that difficult, the cohabitation within even religious people and indigenous people with other beliefs. Even the indigenous people have or also sustain Christianity, for instance. Some of them are Catholic, some of them are Pentecostal, and that's with no persecution or with no other trends that are dangerous for their lives, as it happens in other countries. So, being said that, I have to say that it's not that pacific, although the situation in our region. And that's mainly because it's not we don't have a text direct to religious freedom. It always goes with some other human rights, such as freedom of speech, freedom of association, or freedom to teach. I mean, there are other ways that they try to erode at the end religious freedom. And so for us, the main question is how to avoid religious persecution in Latin America when we are seeing in a fast way the secularization of our society in a way that religion is no longer for granted, and a place where everyone is welcome with their own beliefs, also in the public sphere. That's why we still don't think that, for instance, the burn of some temples or the offensive graffiti in some temples also are an attack to religious freedom, but mainly because of the desinstitutionalization of all the entities that have some power in society. And that's why, for instance, the Catholic Church especially, who was always a mediator in conflicts, now it's not even that called in some conflicts. The recent cases that we have seen in Nicaragua, for instance, at the end were attacks on the Catholic Church instead of being a mediator in that conflict. And the last successful mediation was in Colombia with the FARC giving up their armaments. So there are some issues that are concerning, but they don't arrive to the standards of religious persecution. That's why all the efforts now are made to protect religious freedom, making it more coherent with the other human rights in a way that pacific coexistence can still be for granted in our region. At the end, I would say only that perhaps one of the main helps that we have here is because of indigenous people beliefs. They are always accepted even more than traditional religions, and they have a space in our society that's granted for everyone. So perhaps the standard for all the other religions has to be to look to indigenous peoples and what they have recognized in order to also the other religions have the same standard. And that's what we are working now in trying to do that and trying to avoid the places or the ways of serious persecutions that are in other places. Thank you.
Thank you, Professor Hill.
The American journalist Ambrose Bierce was best known for his publication The Devil's Dictionary in 1911. In it, he defined war as God's way of teaching Americans geography. In preparing for today, I wonder whether religious persecution is God's way of teaching all of us geography. Africa consists of 54 states with radically different histories, faiths and cultures. My brief was to describe and not evaluate. This paper provides 3 snapshot national studies: Nigeria, Algeria, and Eritrea, plus some general remarks. I'm grateful to Tom Hellenbrand, a pioneer student on my new International Religious Liberty course on the London Law Programme, for his industrious research. There are 2 primary international legal instruments that provide for the protection of religious freedom in Africa. First, the International Covenant on Civil and Political Rights, which is designed to translate the Universal Declaration into binding legal obligations. Article 18 provides, everyone shall have the right to freedom of thought, conscience, and religion. The covenant has been ratified by almost all African states, giving the impression that it constitutes a powerful mechanism for embedding and enforcing religious freedom. In reality, the Human Rights Committee of the United Nations, the treaty body responsible for monitoring compliance with the covenant, prepares national reports, but is entirely toothless when it comes to enforcement. Second, a majority of African countries are signatories to the African Charter on Human and People's Rights, the so-called Banjul Charter. It provides in Article 8 that freedom of conscience, the profession and free practice of religion shall be guaranteed. No one may, subject to law and order, be submitted to measures restricting the exercise of those freedoms. The Charter is enforced by the African Court of Human and People's Rights, a regional human rights court based in Tanzania. But the reach and effectiveness of the African Court is limited. 75% of states do not comply with its judgments, and the court has accepted no religious freedom cases since it issued its first judgment in 2009. The Covenant and the Banjul Charter provide scant protection for the millions of people in the 3 countries covered in this paper who seek to practice their faith. They are wholly ineffective mechanisms for holding states and non-state actors legally responsible for acts of religious persecution. Nigeria is Africa's most populous country, over 200 million people. Section 38 of its constitution includes an express provision securing freedom of religion. The population is split fairly evenly between Christians and Muslims, religious demographics overlapping with ethnic identities. House of Fulani in the north are majority Muslim. The Igbo of southeastern Nigeria are majority Christian. And the Yoruba of southwestern Nigeria have large populations of both Christians and Muslims. Violence between different religions and ethnic groups has increased in the past decades, due in particular to the enlargement of the jurisdiction of the Sharia courts of appeal. There are several jihadist groups operating in Nigeria, and the government has failed to combat their violence and their destruction. Boko Haram, meaning literally Western education is forbidden, is the most infamous jihadist group in West Africa. It is an Islamic militant group that developed in the early 2000s to overthrow the Nigerian government in the north, which it perceived to be materially and spiritually corrupt. It sought to establish an Islamic State. And in addition to government, military, and police targets, Boko Haram has launched violent attacks on churches, religious schools, and seminaries, as well as abducting and executing Christian clergy. The Catholic bishops in Nigeria argue that Fulani herder militants are adopting an increasingly violent jihadist ideology. Their attacks are systematic, organized, and deliberately target Christians and their property. To some, these persecutions may probably be defined as acts of genocide. 17 Nigerian Christians were murdered every day during the course of 2021. Men and boys killed, while women and girls are abducted and used as ransom in human trafficking or as slaves. The Nigerian government has been criticised for its inability or unwillingness to take adequate measures to prevent religious persecution. Government's resources are thinly stretched. The police and military are unable to protect communities, even when tipped off about impending attacks. The United States response seems to be trending in the wrong direction. In 2019, the US Department of State included Nigeria on its special watch list. In December 2020, it designated Nigeria as a country of particular concern, something which the United States Commission on International Religious Freedom had been recommending every year since 2009. Last year, the US State Department recommended Nigeria's designation as a country of political concern. Instead, the US Secretary of State Antony Blinken designated Boko Haram and ISIS West Africa as entities of particular concern. This came a day before Blinken's visit to Nigeria as part of his multi-state mission to Africa. The US Commission chair responded that she was especially displeased with the removal of Nigeria from its country of particular concern designation. Political and commercial interests clearly outweighed concern for religious persecution. Moving to Algeria, a North African country on the Mediterranean Sea, population of 43 million. Algeria's religious demographics differ quite significantly from those of Nigeria. In contrast to the relatively equal Muslim-Christian divide in Nigeria, over 98% of Algeria's population is Muslim. Only 0.3% is Christian. Religious persecution in Algeria is increasingly attracting international scrutiny. Whilst its constitution provides for religious freedom, it's not lived out in reality. Religious persecution differs in type from that I've described in Nigeria. It predominantly involves top-down persecution by the Algerian government. In 2006, Algeria passed an ordinance requiring all places of non-Muslim worship to be authorized by a national commission, an ordinance which has not fully been brought into effect. There are penalties which include prison sentences and fines, and blasphemy convictions in recent years have increased. In April of last year, an Algerian court sentenced a prominent Islamic scholar to 3 years in prison for posting opinions on social media that were deemed to violate Islamic precepts. Algerian courts have also handed down lengthy prison sentences to Ahmadi Muslims found to have worshipped without legal representation. Religious persecution in Algeria is top-down, perpetrated by government agencies, apparently acting within the law, and it targets religious minorities which do not conform to the state religion. Eritrea, in contrast, small African state bordering the Red Sea, population of 5.4 million, of which 51% are Muslims, 47% Christian. Particularly challenging to write about religious persecution in Eritrea because of the government's tight control of the press and social media. There is no independent press in Eritrea, and it has been rated the most censored country in the world. Nevertheless, anecdotal reports amply demonstrate the government's persecution of religious communities. Eritrea differs from Nigeria and Algeria because its government is actively hostile to religion itself and seeks to restrict its influence on Eritrean public life. It too is categorized as a country of particular concern. There are far more examples which I will pass over simply to reach some words of observation by way of conclusion. It's bold, it's foolhardy to speak of the elimination of religious persecution in Africa. Constitutional provisions exist to declare and enforce the right to freedom of religion, reflective of international treaties and norms. But these constitutional provisions have little meaningful effect. Freedom of religion is not upheld by law enforcement officers or by the judiciary. Indeed, much of the religious persecution is state-sponsored or condoned by the active or tacit complicity of the military. The African Charter makes high-vaulted claims guaranteeing the free practice of religion, but its enforcement in the court is woefully ineffectual. The United Nations reports can denounce religious persecution, but short of military intervention by a UN peacekeeping body, the institutions of the UN lack the standing and the tools to combat it. Bodies such as the United States Commission are highly effective in collating information, but as we've seen in the case of Nigeria, a recommendation that a nation be designated a country of political concern can easily be overridden as a matter of political expediency. Keeping these instances in plain sight is essential. Calling them out for what they are remains an important task of all of us. This university's Religious Liberty Initiative and its programme on church, state and society is essential to ensuring that a spotlight is shone on those places in the world where religious persecution is exercised. As Albert Einstein himself observed, the world is a dangerous place, not because of those who do evil, but because of those who look on and do nothing. Thank you very much.
Thank you, Professor Hill. We now turn to Professor Turkel.
Thank you so much. Thanks for having me here. It's great. Great panelists. I know they selected a rapporteur for the Middle East attentively, but he couldn't come. That's why I'm here. So the Middle East is the usual suspect, of course, and there are many statistics about the degree of persecution against Christians. So I'm focusing on them, although you can expand to more and more religious minorities, even to power struggles among Muslim denominations. So Christians used to be 20% of the total population in the Middle East. Now they are down to 5%. Afghanistan is the worst country for Christians. On the list of the most persecutory countries against Christians, it has replaced North Korea at the bottom. Persecution, however, is not a trademark of the Middle East. So although it's a usual suspect, it would be good to have some perspective. Let's take Iraq. In 2003, when the US-led coalition invaded Iraq, the Christian community was composed of some 1.5 million members. Now it has dwindled by 83%. It comprises only 250,000 individuals. In Palestine, Christians have decreased by 87% in a few decades and are now below 1.5% of the population. In Syria, they were 1.7 million in 2011 when the Arab Spring began, to below 450,000. And if you take Aleppo, this wonderful historical city, it used to have 360,000 Christians, now they are 25,000. So if we look at the watershed, there are two main momentous time changes in the Middle East. So the regime changes in Afghanistan and Iraq and the Arab Spring. So contrary to the expectations, these changes did not help Christians and did not help other minorities. Let me focus on Afghanistan and Iraq for the role that we as Westerners play. So what can we learn about how we look at the Middle East? This is the takeaway that I would like to propose to everyone. So in the Middle East, we have tried to promote religious freedom as key component of core constitutional values and principles, including human rights, democracy, and the rule of law. Let me focus on the rule of law. Nobody here needs to be lectured about the rule of law, but let me just summarize some of the aspects I'd like to focus on. The rule of law, in its essence, requires at least that there's equality among citizens, that one of the same law is applied for everyone, that the same judge should adjudicate cases about everyone regardless of religious or ethnicity. Laws must be predictable and enforceable by courts. Courts are fora that hear complaints and pursue justice for all. And most of human rights and democracy stem from these premises from a historical point of view, in contemporary constitutionalism at least. So the problem is that the Middle East does not operate this way. So within the Islamic and even non-Islamic cultural framework, religious and ethnic communities are the primary legal and political subjects and require loyalty from their members. Claims are addressed by community leaders and through negotiations among communities. The state political sphere is an offspring of multiple religious and ethnic communities that mutually recognize each other. Public institutions provide room for inter-ethnic and inter-religious negotiations. They don't make decisions. They just give room for groups to make decisions. So if we look at Saddam and the Taliban, they either adhere to this logic or exploited this logic, although they did often this in vicious ways. But we didn't. We tried to uproot this logic. And this is something that is probably going to alienate me some sympathy within this room. But we try to enforce the rule of law. As a result of it, superimposing an individualized logic of rights and duties over group-centered societies. Judicial fora replicated this logic and replaced negotiations with precise and often individualized claims. This has undermined the cohesion within communities and the negotiation process among communities. Equal voting rights never took off because individuals tend to vote according to their ethnic or religious affiliation. If you are a Shia, you vote a Shia. There's no question about that. Finally, and most importantly, the democratic process has allowed ethnic or religious majority that won at the ballot boxes to stop negotiating with minorities and actually leveraging the law to discriminate against them. So my suggestion is that we should probably have considered the constitutional system, which is known to the West. It's not the best option, but can probably better protect minorities, although we should be aware that where constitutions took roots, they hardly evolved into religion or ethnicity-blind, fully fledged democracies. So this also addresses the question you posed at the beginning, I think. A final warning. So one of the great things about the Middle East is that various communities have always lived there. It wasn't like Algeria, where there were basically no Christians, just Muslims and Sunni Muslims. The region has experienced what it means to live in a pluralistic environment, although it hasn't always created constitutional settings to reflect or protect it. If minorities flee, that experience will be lost. So it's not just about the law. The Middle East might achieve religious freedom for minorities in the future, but minorities might not live to enjoy it in the Middle East. And who remains may have lost the opportunity of experiencing diversity forever. I'll stop here. Thank you.
Thank you very much, Professor Finn. We now turn to Professor Scharffs.
Thank you very much. I'm really happy to be here at Notre Dame Law School. This is a place I admire and respect deeply, and I've been here several times and always enjoy my time here. I want to really congratulate the Notre Dame Law Review for this series of symposiums. To be holding a series of symposiums like this over the course of the year is really a remarkable effort to be engaged and to be at the forefront of important legal issues. And I'm grateful for the inclusion of the question of religious persecution on the agenda. I want to also just note that the law review student who's been in communication with me, Micah Allred, has just been absolutely fantastic. Would be a tribute to any institution to which he was a part. And if he's indicative of the quality of the students, then you're an even more remarkable institution than I know you to be. I'm also really impressed with the new Religious Liberty Initiative here at Notre Dame Law School. Of course, this is in part because of one of my good friends and former colleague, Stephanie Barclay, is the director of that. But it is such an important, fresh, and valuable new voice in the area of religious freedom here in the United States and globally. And in that regard, I want to also commend your dean, Marcus Cole. I think he's one of the most remarkable and impressive deans in all of legal academia. And for you to have him at the helm leading Notre Dame at this time, I think is a real blessing for this institution. And I'm just really have been watching with real amazement at the good things that have been happening at Notre Dame across the board. So you're really on a roll, and it's not an easy time to have been on a roll. And of course, I can't conclude without thanking, my good friend Rick Brunet and Nicole, the work that they're doing with the Church, State, and Society program, and Nicole helping oversee the Religious Freedom Initiative while Stephanie's back doing her Supreme Court clerkship. It's a remarkable team that you have here. And the heart and soul of law schools are the faculty and the students. And by those measures, you're doing exceptionally well. The title of my presentation is The Journey from Persecution to Inclusion, a case study of the Church of Jesus Christ of Latter-day Saints. And my focus is their journey here in the United States. Several years ago, I became acquainted with a woman named Baroness Emma Nicholson of Winterbourne, who's in the UK House of Lords. She is also the founder and chair of the Amar Foundation, which is a charity that strives to build and improve the lives and livelihoods of some of the world's poorest and most disadvantaged people. She has a particular heart for the Middle East and for the refugees in Iraq, and in particular, the Yazidi people. And she invited me to participate at a conference in Baghdad, focusing on the latest wave of persecution faced by the Yazidi, a minority religion that has suffered long history of misunderstanding, persecution, and attempted genocides. Along with several ecclesiastical and humanitarian leaders from the Church of Jesus Christ of Latter-day Saints, we were asked to share the experience of the journey from persecution to participation and inclusion of the Latter-day Saints in America, with the hope that there might be ideas or insights that could assist the Yazidi people in navigating their journey. And this essay is a summary version of a chapter that David Kirkham and I are writing for a book about the journey from persecution to inclusion that has emerged from our work with the Amar Foundation. At that conference in Baghdad, I heard the account of young Yazidi girls who had been taken captive and sold into sexual slavery, often handed from husband to husband over the course of several months. One girl thought she recognized one of her captors, and although it took her some time to connect the dots, she came to realize the man who was raping her had been her family's dentist. This story illustrated that religious persecution is not something abstract that occurs far from home. It is people whose lives intersect with their victims, neighbors, who are often the persecutors. And it will often be neighbors who are the ones who offer support and aid to those suffering from persecution. And so, in this little paper, I focus on 7 institutions and the people who inhabit them. Let me just list them for you. First, the state. Second, other religious communities. Third, media. Fourth, the persecuted group themselves. That one's a little controversial. 5, businesses. 6, neighbors. And 7, academics. Now, this is the question that came to really intrigue me. When you hear that list of institutions, do you think of them as the cause of the problem of persecution or as the solution to the problem of persecution? And perhaps it is obvious to you, but for me it was a major insight to recognize that the answer is both. It's the very same institutions and the very same people, sometimes different people within the same institutions, that are either the perpetrators or the defenders of religious persecution. And so, as I focused on the history of the Latter-day Saint people, one thing I noted was that in the first 20 years of the history, the church endured 4 major forced migrations within the United States. First, they were driven from New York to Ohio, where they settled in a town called Kirtland and began work on a temple. They were then driven out of Ohio and went to Missouri, where, if anything, things quickly became worse. There they were subject to the infamous extermination order issued by the governor of the state of Missouri, which labeled Latter-day Saints as enemies and as subhuman, and basically declared open season on them. That winter, the church's founder, Joseph Smith, spent cold, dark months in the aptly named Liberty Jail. And after that, they settled in Illinois, in a town called Nauvoo, which soon became the second largest city in Illinois. Some say it was even larger than Chicago. This was a long time ago, so Chicago and this was still the Wild West. Partly, I think, because they gathered and had an instinct for gathering, they were again quickly perceived to be a political problem. Joseph Smith and his brother Hiram were murdered while they were in prison, and during the cold winter of 1845, they were forced to flee. It was so cold as they left Nauvoo that they crossed the Mississippi River in their wagons with oxen on the ice. The river was frozen solid. And 2 years later, they arrived in the Salt Lake Valley, which was largely a desert that was mostly uninhabited. There were some Native American peoples there. What this history shows is that even in the United States, the experience of persecution is real. And even having arrived in Utah, the persecution didn't end. The state sent in the military because of a rumored insurrection that actually wasn't happening. There was also, of course, a legal struggle to eliminate the church because of its practice of polygamy during the 1860s, 1870s, 1880s, until the church formally abandoned the practice in 1890. Of course, it took a generation or so for it to complete its end. And some fringe groups broke off and still practice polygamy, first fleeing to Mexico and then to Canada for safety and refuge from the oppression of the United States, and now gathered in small communities in mostly the Southwest United States. The bulk of my paper focuses on these institutions. The state was an instrument of persecution, both at the federal level and at the state level. Similarly, other religious communities were a source of persecution. The Protestant majority in the United States has persecuted many religious minorities, including Catholics. The media was a source of persecution, especially if you look at newspaper accounts and political cartoons from the era. There's one that I wanted to show you that has twin reptiles climbing on the dome of the US Capitol. One is an alligator and one is like a serpent. And one is labeled Popery and the other is labeled Mormons. And these are the twin sort of amphibious creatures that are a threat to the country. The persecuted group themselves can contribute to their own persecution. And this is a delicate and sensitive topic because we don't want to blame the victim. But there are certain things that the church did, the practice of polygamy being the most obvious, but also their anti-slavery stance in Missouri, for example, which was the primary reason that they were driven out of Missouri, or their propensity to gather and to vote in a block to protect their interests, helped bring persecution on themselves. Similarly, businesses and neighbors and academics, if you look at the encyclopedia entries on the church from the 19th century, you'll be shocked that they count as academic writing. Well, the truth is, all of these groups also included people who came to aid and defense of the church along the way. There were people within the state institutions. There were lawyers and judges who treated the church fairly. There were businesses that engaged in business with them. There were neighbors who welcomed them. When they fled from Missouri, there was a whole community that took in Latter-day Saint refugees and protected them through the winter in Quincy at a time when they were extremely vulnerable. Well, my time is up, but my thinking about persecution was forever changed when I heard that story of the young Yazidi girl who recognized the man raping her as a family acquaintance. This suggests that at times of stress, neighbors who live peaceably together can turn upon one another. It also illustrates how close to home religious persecution, and I might say other types of division and ugliness, can be. It was in the aftermath of that conference, in reflecting upon the experience of Latter-day Saints, that I saw in an instant of clarity, a little like a light being switched on in a darkened room, that the sources and the solution to persecution are one and the same. I focus on institutions that you are likely already a part of or will be soon a part of. I concluded with academics because I want the implications of the analysis to be personal, since I am an academic who studies law and religion from an international and comparative law perspective. Each of us, and from whichever institutions we inhabit, is capable intentionally or unconsciously of being either a part of the problem or part of the solution. My hope is that I will be on the side of those who come to the aid of minorities, including religious minorities, who suffer persecution, just as there were those who came to the aid of my own religious community at a time when we were particularly weak and vulnerable. Thank you.
Thank you, Professor Scharffs. We now turn to Commissioner Turkel.
Thank you very much. Thank you. I'd like to begin by thanking the Notre Dame Law School Religious Liberty Initiative for bringing us here, and I'm particularly grateful to Dean Cole, Professors Desierto and Berkeley for their leadership in promoting and protecting religious freedom around the world. I echo Professors' sentiment and compliments for our colleagues in the law review. I wanted to thank Professor Hill for highlighting the work of USERF. I echo your concerns, share your concerns. My paper focuses on two key issues. One, how CCP, Chinese Communist Party, perceives religious practices in the PRC. And also the second question that I covered, discussed, is the role of technology in religious persecution in Communist China. When Chinese leaders, including Xi Jinping, look at the society around them, they see plenty of potential threats to the power and existence of the Communist Party. History, civic engagement, activism, more relevant to religion, most relevant to the CCP is the religion. The leadership believes that its capacity to energize large masses of people in pursuit of goals to counter the CCP's power and legitimacy, that is the main concern for them. Particularly, General Secretary Xi Jinping has developed a succinct strategy towards any potential institution that could detract from his own singular authority, that is to co-opt what could be useful to his own power and destroy the rest. She and previous leaders have long employed a dual-track strategy towards religion. Historically, CCP leaders have selectively welcomed the rise of traditional Chinese Buddhism and folk religions when they can be used as a source of positive promotion for socialist regime. However, in any inclination that followers of these faiths might organize into block with political influence, the party has always ready to fully outlaw or discourage such religious practices. Beyond Buddhism and folk religions, China officially recognizes 5 religions: Buddhism, Taoism, Islam, Catholicism, and Protestantism. While these religions are officially sanctioned, the PRC Constitution guarantees the right of freedom of religion and beliefs. China's regulation on religious affairs require practicing religious groups to register their organization and activities, and the state reserves the right to decide what activities are legitimate within the context of these approved groups. That includes large-scale religious activities must be held within their designated locations, and anyone could be found to be participating in unsanctioned religious activities, including providing a venue for them, is subject to criminal persecutions. On September 4th, 2021, Xi Jinping continued his crusade to limit the fundamental religious practices of even those 5 recognized religions by publicly and explicitly stating that these religions can be only tolerated in China insofar as they conform with the country's socialist society. At the most recent National Religious Affairs meeting, Xi Jinping stressed the cynicization of religion. He commissioned a reinterpretation of key religious texts from the major religions present in China. The CCP calls for, quote-unquote, comprehensive evaluation of the existing religious classics, aiming at contents which do not conform the progress of the times. While Xi's treatment of all religious groups in China has been incomparably horrific, he has saved his most heinous crimes for the Uyghurs, the ethnic and religious minority group living in what China calls Xinjiang Uyghur Autonomous Region. Since the CCP came to power in 1949, they have taken special notice of the Uyghurs, fearful of their vibrant religious practices and culture. However, under the Xi Jinping regime, this special notice has reached a new height. By this point, awareness of the genocide that Xi and his political allies perpetrating against the Uyghurs are growing. Xi's directives has been interpreted discretionarily by Chinese officials at the local level, complicated the reality as Xi Jinping's speeches since 2014 contain languages that has alternated between hardline and appeals for tolerance for religion. As a recent purge of officials deemed to be too moderate in their approach revealed, and any allusions to respect for religious practices was merely lip service to the Chinese law. It is also revealed that the Chinese leadership implemented draconian measures to advance its religious persecution policies. Growing number of parliaments around the world with respect to the ongoing genocide officially recognized what's happening to the Uyghur people as a genocide and crimes against humanity. Last week, the French Parliament officially recognized, joining the effort led by the United States to make 8 countries out of 152 state parties to the Genocide Convention. The rest of them are still avoiding to take responsibility. CCP also has employed best and brightest in the pursuit of designing the most innovative, well-oiled genocide on religious grounds the world has ever seen. For years, the CCP has worked to develop and integrated technological, diplomatic, logistical approaches to oppressing Uyghurs, depressing Uyghur culture, religious practices, and repressing information about the genocide from reaching outside the world. Video cameras equipped with facial recognition software are omnipresent in cities and villages. Cell phones come equipped with mandatory spyware apps that record every aspect of Uyghurs' online activity. Uyghurs must have their ID cards scanned at ubiquitous checkpoints to gain access to parks, malls, and stores. These scanners are linked to broader policing technology. If an individual identified as risky, then entry will be denied. Officials in Xinjiang use this data along with biometric data that Uyghurs are required to submit to the government officials to determine who should be sent to the concentration camps or facilities participating in slave labor. China's treatment of religious groups as compared to other potential threats is different in kind, not just the degree. Religion poses a unique threat to the party because it provides compelling and empowering alternative to its ideology and cult of personality. The only worship to party is truly compatible, comfortable within its ideology and policies. So despite creating its holidays, idealizing religion, idealizing the leaders, and literally rewriting the book on major religions over the decade, Chinese leaders have found that in most cases, they cannot fully insert themselves in the spiritual and communal lives of the religious individuals. CCP has developed systematic approach to repressing religious groups around the world, has watched it played out model for completion first. But now the Chinese way of using technology to monitor its vulnerable communities is metastasizing. Over 80 countries have adopted Chinese form of surveillance. While international law might not be implementable and the domestic legal form for accountability exists, the Chinese tech companies, for example, have developed, tested, exported surveillance technologies, as I pointed out, falls under the jurisdiction of our courts here in our country. We should call the companies to account. I've been calling to the US government to investigate the businesses that have been complicit in the ongoing genocide. With that, I conclude my remarks and ready to take questions.
Thank you, Commissioner Turkel. And finally, for last speaker on this panel, Professor Sonne. Can you hear us?
Thank you. Can you hear me okay?
Yes, we can. Thank you.
Great. Well, thanks so much, Professor Desierto, Micah, fellow panelists, sponsors, and all of those in attendance. My apologies for the travel woes that lead me to needing to appear by Zoom today, but I'm so glad I could be there virtually. It's for sure a special privilege to be with you, given the founding and abiding ties between the Religious Liberty Initiative there and our Religious Liberty Clinic here at Stanford, as well as my personal fondness for Notre Dame Law School, Dean Cole, and your world-class faculty. It's also an honor to speak today about one of our clinic's most cherished client communities, the Sikh community, and in particular, the precarious situation that many Sikhs are facing in contemporary India, and in turn, the obstacles they meet in fleeing India to secure asylum in the US. To that end is the article for the Symposium, which I co-wrote with Trip Henningsen, a former clinic student of mine and the lead drafter of an asylum guide that we published last fall in partnership with the Sikh Coalition and friends of the new Harvard Religious Freedom Clinic. In short, our article seeks to highlight the situation facing Sikhs in India and help asylum counsel and US immigration officials facilitate much needed relief. Trip and I are grateful to the Notre Dame Law Review for the chance to tell that story. In the brief time I have, allow me to flag the problem, describe two of its chief causes, and make a closing appeal. Naturally, I can't unpack it all in 7 minutes, but that's not my goal today. Rather, my goal is to highlight the Sikh experience in India and show that even in situations involving a stable democracy and allied to the US, we should be ever mindful in the defense of international religious freedom, and also wary that the persecution of religious minorities can happen anywhere, and can be particularly pernicious, whereas for many Sikhs in India, it could be obscured by a veneer of stability and a somewhat elusive combination of factors. So what is the problem? Well, as our article observes, Sikh asylum claimants from India are clamoring for safe haven in the US in the face of past or threatened beatings, assaults, detentions, or other forms of persecution on account of their Sikh identity, beliefs, or activities, and at the hands of private individuals and mobs, as well as police or other pro-government actors. Sadly, however, their claims too often fall on deaf ears, or are presented in an inadequate way by counsel or by the claimants themselves. This is due to a variety of causes, but two seem to predominate. First, there's a lack of background awareness of the persecution facing many Sikhs in India. And second, it can be difficult for Sikhs to map their suffering onto the designated legal categories for securing asylum in the US. So let's take the first of these causes. There's a general lack of awareness in the US generally, and in our immigration system specifically, about the historical and contemporary challenges facing Sikhs in India. Worse yet is that this ignorance arises alongside a default assumption about the state of Indian democracy. Surely these things don't happen in a modern and internationally engaged nation whose prime minister has been welcomed by American presidents and officials of both parties alike. And yet, Sikh persecution has not only festered for a long time, it is again reaching a boiling point. Looking first to history, the challenges that Sikh asylum applicants face have been with the Sikh community in India for centuries. Whether viewed from the vantage point of its founding in the contested and religiously diverse Punjab region of modern-day India more than 500 years ago, experienced in the challenges of the colonial period and then bloody dislocation that followed the partition of the subcontinent in 1947, or burned into the living and collective memory of Sikhs around the world through the retaliatory violence that followed Indira Gandhi's assassination in 1984, a cycle of suffering could be said to be central to the story of Sikhs in India. And unfortunately, the situation has again become worrisome in recent years with the rise of a nationalist movement that views Muslims, Sikhs, and even Christians as the other and as a threat to Indian culture and the nation. Perhaps the most well-known recent example of this mistreatment of religious minorities is the spate of anti-Muslim violence spurred by a 2019 amendment to the Indian Citizenship Act that excluded Muslim immigrants. Nationalist persecution can also be seen in the widely covered attacks on Muslims, Christians, and others following the recent passage of anti-conversion laws in many Indian states. And perhaps a fair number of you read about the recent ban of foreign giving to Mother Teresa's Sisters of Charity, a ban that has since been reversed but was quite the signal. When it comes to Sikhs, however, although the story of anti-Sikh hostility in India made some news last year in the persecution of those protesting the passage of agricultural laws that disfavored Sikh farmers, including retaliatory violence, the jailing of journalists, and warrantless surveillance or other acts of intimidation, the saga is largely hidden for US audiences. Fortunately, USCIRF and certain leading human rights groups are on the case. Indeed, USCIRF recently did designate India as a country of particular concern. But more needs to be done to highlight the issue for the benefit of Indian Sikhs who seek safe haven here and for America itself. As for the second cause of difficulty for Sikh asylum claimants, there is the all too common lack of appreciation by US asylum officials, or perhaps a failure to communicate to them, about the unique nature of Sikh identity, beliefs, and practices as they relate to the three relevant grounds for asylum in the US, namely a well-founded fear of persecution based on the applicant's religion, politics, or membership in a given social group. To some officials, Sikhism, or Sikhi as the community calls it, is a religious phenomenon involving specified rituals, dress, grooming, and diet norms, and other discrete forms of spiritual practice, analogous to those in Islam, Christianity, or Judaism. To others, Sikhism is a political movement that advances a particular worldview and stands up for an established community of people in Punjab, perhaps to the point of advocating for a separate nation state called Khalistan. And to still others, Sikhs are a high-profile yet marginalized social group that accounts for a mere 2% of India's population of more than 1.3 billion. Given these three narrow perspectives, or lanes of asylum inquiry, it's not uncommon for Sikh asylum claims to fall through the cracks. If, for example, the focus is on traditional religious exercise, the asylum official might fail to grasp, or the claimant fail to express, the variety in faith practice among Sikhs. A prime example is that younger Sikhs now increasingly cut their hair in contrast to the traditional practice of kesh, or unshorn hair. Similarly, asylum officials might not know that religion in the life of a Sikh can have as much to do with culture than outward worship. In other words, a Sikh can suffer religious persecution even if she doesn't follow traditional practices or still has access to services at a gurdwara. Alternatively, if the focus is on political or social group persecution, the asylum official or claimant might struggle to capture or express the nature of Sikh engagement in political or social affairs as no mere secular exercise, but as a central part of the Sikh faith. From its start, and in contrast to the surrounding caste system and other religious traditions in India, a core part of Sikhi is the so-called Miri Puri philosophy, which stresses civic engagement, equality, and other political or social engagement for Sikhs as a religious command. What might not rise to the level of actional, political, or social persecution, given representative avenues in Indian democracy, therefore, may well trigger protection under a religious rubric where such avenues do not satisfy. For example, where a mainstream Sikh political party might not address the plight of the individual activist, a not uncommon problem in the asylum arena. I realize my time is running short, so allow me just to close with this. Download our article, take a look at the guide that we published with the Sikh Coalition last fall, and join us in more closely examining what's happening in India to Sikhs and other religious minorities, for their sake, for our sake, and for the wider cause of international religious freedom. Thank you.
Thank you very much, Professor Sonne, and I realize that we are well on track with time. I would like to invite everybody to go back to the title of the symposium, which is to rethink how we ensure the protection of religious minorities. Our panelists, distinguished panelists, have given very provocative research, and I had the great privilege of reading the advanced drafts of all of the contributions to the law review. And what seems to me quite clear is that while we have a proliferation of standards, international standards and counterpart jurisprudence that look at religion and the protection of religion indifferent for it, there's a question of whether or not this is a question to be rethought in law or outside of the law. And so to the extent that we look at religion as a prohibited ground of discrimination, religion as a separate basis or entitlement to specific protection, or religious freedom as one of the non-derogable norms in international human rights law, it invites me to think that back in 1967, the third international human rights treaty that was supposed to have been concluded was the Draft Convention Against Religious Intolerance and All Forms of Discrimination Against Religion. That did not pass in 1967 when the Six-Day War erupted. At that point in time, the United Nations system was overcome by the ensuing conflict between Israel and the Middle East. Is this, therefore, based on the presentations that we've heard today, with Latin America wrestling with extreme secularism and the absence of explicit text, the need to try and draw from constitutional nexus to establish religious protection, or from what Professor Hill describes as the rampant state incapacity and deficiency in resources and enforcement problems that we already have in the international system, or what Professor Pin points out as the utterly wrong paradigm that we try to inflict in constitutional drafting when we don't understand the role of religious institutions or associations as intermediaries for decision-making. Or what Professor Scharffs aptly pointed out, that religious freedom can occur right in our own neighborhoods, from institutions, but also at the most basic level of what our fundamental human interactions could be. And finally, from what Professor Sonne and what Commissioner Turkel have pointed out, what do we do in the face of overwhelming state power brought to bear that regularizes or routinizes religious unfreedom and religious persecution? It does make me wonder, and this is a question I'll pose to the panelists, is it time to start thinking of a separate convention, a separate instrument, a separate institution that safeguards religious freedom and ensures the protection of religious minorities in 2022? And perhaps I'll begin to my rightmost with Professors Rojas and Celis, and then proceeding all the way to Professor Sonne.
To me, I agree in that perhaps it's the time of a convention. To me, it's always something to think about. It's why in Latin America we don't have a convention, because we don't have the pluralism that it's already in other places of the world. And perhaps the time has passed, and now it wouldn't be possible. You have to remember that before the Declaration of Human Rights in 1948, there was the Latin American one. And we were very strong in that issue, and then it disappeared from the contest. And because of discrimination, that would be something, or a conflict between rights that now needs more protection than in other times, but I'm not sure that politically you could achieve that.
Thank you, Professor. Shall we turn to Professor Hill?
Well, I think you would have picked up my tone of cynicism as I was driving through the various observations I had in Africa. Another treaty would be marvelous. It would be wholly ineffective in changing any of the problems that I've outlined in my territory and fellow speakers have outlined in them. We do have a new treaty in the form of the Punta del Este Declaration, which moves the focus away from rights and onto human dignity. And I think Professor Scharffs might say a few words about that, as he was the prime mover behind that one in particular. But where we have a situation when existing treaties are ineffectual, where national constitutions which make express provision for the protection of minorities are ineffectual, we need perhaps to look somewhere else. And when we have seen through political expediency, other nations are reluctant to act and call out persecution for what it is. I'm reminded of the recent death of Archbishop Desmond Tutu. What brought apartheid down was economic sanctions. It wasn't treaties or anything else. And maybe that's where the International Committee of Nations needs to act collectively.
Professor Rojas, I neglected to call on you earlier.
Thank you, Professor Desierto. And I think that under Latin American perspective, we are living difficult times to address these questions. And I want to say why. The extreme secularism in some countries maybe is a worse moment to start a discussion to write a provision about religious liberty when even some authors have wrote about eliminate from the treaties just because to maintain freedom of speech or the right to association, and that is enough. So religious liberty is no longer necessary as a provision in the treaties. I think that the problem is that the professor says is more related to mechanisms more than the current law in force. Even in the cases of extreme or severe religious persecution, the fact-finding process is good to show to the world what is happening in this situation, but it's not enough to put an end or put the end the religious persecution in countries like Afghanistan, what is happening, for example, with the Shia Hazara community, or what is happening in the Ahmadi community there. So I think that it's the same in Latin America. It's not time for drafting law more than improve the mechanisms.
Thank you. Professor Pin, you put forward the proposal of consociations, and how do you intend to operationalize this proposal? Is it supposed to be organically created by the different religious communities themselves in a constitutional drafting exercise, if not in an international treaty?
So what brought consociations to life was the necessity of ending violence and brokering peace. And that was when international organizations and global powers stepped in and persuaded everyone that this would be the best compromise. So I would go with that.
Thank you, Professor Pin. Professor Scharffs, you did point out the journey of the Latter-day Saints from discrimination and persecution to inclusion as being a project that occurred organically in many instances, but over time. Is this something that you think could still be done today, could still be achieved today, absent rethinking the law as we have it today?
Well, I wish I could say that I thought the time was right for an international treaty with respect to freedom of religion and belief, but it almost certainly is not. The likelihood is that whatever came out of such an effort would be either a failure or so much weaker than what we already have that it would be a major step backwards. Currently, the primary instruments are the Universal Declaration of Human Rights, the International Civil and Political Covenant on Civil and Political Rights, and the 1981 Declaration on elimination of all forms of intolerance. Together, these are pretty good in terms of what they say, and by far the most effective human rights treaty is the European Convention on Human Rights, which actually does have an enforcement mechanism which works reasonably well. Why do I say that it would be weaker or unsuccessful? Well, several reasons. The first is that human rights are really on the defensive globally, including in the United States. Think about the way the 1619 Project has dominated our discourse about racial discrimination. The United States has lost a lot of confidence that it once had in its own founding ideals, to the point that some want to even deny them as being our founding ideals. Think of what Nury Turkel was talking about, the situation of the Uyghurs in China. This is a religious persecution unlike anything we've seen in a very long time. The estimates vary, but the numbers you hear are 1 million, 2 million, even 3 million people in labor camps, where the explicit goal is to deinstitutionalize their ethnic and religious identity and to turn them into good citizens. And it has been labeled a genocide. It's been labeled a genocide by the United States. And under the Genocide Convention, that triggers obligations. And we have not triggered those obligations in light of that recognition. Think of the Olympics, which we're about to tune in. USERF made a major effort to get the United States to boycott the Olympics. Unsuccessful. And we have a diplomatic boycott, but how many countries have joined that globally? I think the number is 10. So of the 200 nations in the world, 190 of them are so indifferent, scared, hostile, that they won't stand up and even be counted in a relatively easy way. Now it's not easy on the athletes. I have a nephew who spent 10 years trying to become a ski jumper to compete in the Olympics. And it would be really unfortunate for those people to bear the brunt of the activist opposition. But there's something really wrong when even a genocide involving millions of people is not sufficient to awake us from our slumber. There's the NBA owner just this week who said, on the list of things I care about, I just can't begin to care about the Uyghurs. Now think about that. This is the NBA. If you want to think of a woke social justice activist institution in our society, you'd have to look long and hard before you found someone stronger than the NBA. Yet they are rendered mute when it comes to China. Mute.
And on that note, Professor, may I turn to Commissioner Turkel on what do we do if this is not a question of law, if it's not about rethinking the law to just do better enforcement, or rethinking the law, and what Professor Sonne pointed out is what happens when the human rights violation doesn't fit the categories created by law. What, in your sense, is a role for law in ensuring protection at this time?
Thank you very much. Thank you, Professor, for the excellent remarks on the Uyghur genocide. Two thoughts. One, if there's a necessity to come up with a different type of international treaty. As you all know, that China is also a signatory, a state party to the Genocide Convention. Recently concluded the Uyghur Tribunal, led by Sir Geoffrey Nice, expresses frustration that the nations appear to be avoiding to fulfill their treaty obligation. In the case of the United States, we not only have a treaty obligation, we have a legal obligation. There's a domestic statute that has not been fully utilized. That is one, that's what we should do. And then two, the existing laws. The United States Congress passed Uyghur Human Rights Policy Act, which was enacted in June 2020. Most of that new legislation have not been implemented. Professor is right, it's on us now. This is about what kind of country society that we want. Our sovereignty is under attack, under threat. And our businesses, and I also agree with the list of problems that the academics, media, the business complicity. It's just mind-boggling that in year 2022, we cannot openly, publicly condemn genocide or persecution, systematic, deliberate persecution of religious minority in the United States. That is unconscionable. So the implementation of the existing laws is another thing. And also, we should also look at how can we use the domestic courts? All of the big companies implicated in the ongoing genocide has a U.S. connection. The Silicon Valley, for example. Why the United States Justice Department so immersed in the works like the FCPA, the antitrust investigation, cannot open an investigation of those, investigation into the business entities present in the United States and blacklisted by the US Commerce Department. Recently, something dramatic happened that in December, right before I got sanctioned by the Chinese government along with my commissioners, 7 out of 9 commissioners have been sanctioned since March 2020. The United States Commerce Department blacklisted a Chinese military medical academy and its 11 affiliates for developing brain control weaponry, targeting religious ethnic group in China. So this is the circumstances, this is the situation they're dealing with. I always said this is on us. This is on us to speak out. This is on us to implement the existing laws. This is on us to put pressure on policymakers because there's a lack of interest, not only lack of interest, but lack of political will. So those are the things that I think that we should look at.
Thank you, Commissioner Turkel. And finally, let me turn to Professor Sonne, who interestingly spoke very eloquently about the law as advocacy, and in particular, what we have a role in as lawyers to bring and illuminate on issues that require deeper awareness and probably to try and eliminate outworn or outmoded categories in the law that do not comport with actual human rights violations. Professor Sonne, what are your thoughts at this point about rethinking the current state of law to ensure protection?
Well, I think that's a really good question, and I'm not an international law expert, so I don't have all the answers, but what I can say in our experience here at the clinic, and I know it's a principle that animates Professor Barkley there at the Religious Liberty Initiative and Professor Garnett at the Program of Church, State, and Society, that so much of what we're talking about today comes back to the why. Why is it that religious liberty is important? Why is it, as Pope John Paul II famously said to the UN, that it is the foundation of every truly free society? So really getting at that question of, and the answer of why, and ultimately, at least it's my conviction, that it starts and ends with the dignity of the human person. And once we understand that, we can see the universality of religious liberty, that it's something that is written on the human heart, that it's something that is a universal desire of all people. So we could put together a lot of legal structures, we can dissect them, unpack them, but it really starts and ends with that. And I think that's where I sort of end where I started, which is, in gratitude for all the great work that you're doing at Notre Dame, and in preparing students, in really engaging these issues, and just so grateful that for this symposium and all the great work that you're doing there. So thank you.
On that note, we are now at the top of the hour and closing the symposium. Permit me to invite everybody to extend a round of applause for our panelists for sharing their views today. I now turn over the podium to the Notre Dame Law Review, and thank you for the opportunity to discuss and engage on this crucial topic. Have a good afternoon.